So as far as in your case right now, what is the status of it? Are you allowed to talk about it at all or not?
Yeah. So right now, as far as the divorce matter itself goes, we had a couple weeks ago, we had a hearing before the judge the judge actually said that the fault-finding officer would have been the lawyer who was appointed as divorce master, and the judge was simply, executing the
Divorce master's
findings.
Are there any findings of fact?
And there are no actual findings of facts because the statute doesn't prescribe that.
Yeah.
So our case now is we're simply waiting for the ruling of the judge in her
judicial capacity.
Judicial capacity, right?
Yeah.
And what I suspect is that the divorce master had actually, with his recommendation of divorce based strictly on how he interpreted the statute, which, as I said, he said was above his pay grade and he wasn't able to make that decision. But the judge said that since he had made a decision according to his understanding of the statute and the law, that she simply had to go along with that. And he provided a divorce decree template for her to just sign off on. So I'm waiting for that judgment and whether she finds my exceptions to the divorce master to be valid or not, which were the challenges to the statute.
So I would like, I don't know, obviously neither one of us know what's going to happen here, but I wish that there would be some legal firm. The American, the ACLJ, I think it is, the American Civil Liberty and Justice, J. Sekulow or Liberty, one of the conservative religious-based legal institutes that would take up your case. If somebody took this up and challenged it, they would be doing a service to, I can't tell you how many thousands and thousands of children.
If right now it were to be ruled, if the judge, on Monday says that the motion for summary judgment is denied, and basically my challenges to the statute are denied, and the divorce decree be issued, there's a substantial amount of testimony on the record to appeal the case now. So then it would be appealed to the appellate court. And
have you spoken with any of your either senators or representatives about this? Because judges can be impeached as well.
I have. I've attempted to reach out to the legislators. It seems that none of the legislators are interested in rewriting the divorce code.
I still know a couple, not many, but
I continue to seek that. Actually, the judge in the hearing told me that this seems to be more of a legislative issue that I need to bring to my legislators. But the legislators tell me that they're not lawyers and they don't want to get involved in it either.
Oh, so. They're lying. The divorce court a lot of the code is written by lawyers for lawyers. I was told the same thing. Now, the interesting thing in the Texas Family Code, section 6.001, it talks about the judge may grant divorce based on the cause of insupportability. So to me, may means, and this is just a plain English lesson, I may go to Europe next year, but I may not. And if every time I use the word may, I actually did it, I suppose it's conceivable that it would happen. But you would normally think that over the course of my life, every time I said, well, I may do this, there would at least be some times that I wouldn't do it.
In the 40 years that this has been a statute.
Yeah. That there would be some exceptions, and yet you cannot find them anywhere, which makes the whole thing completely unconstitutional, and a deprivation of your rights. Is there anything else you want to...
Well, it actually says in the Pennsylvania Rules of Civil Procedure 1032B, it says, whenever it appears by suggestion of the parties that the court lacks jurisdiction of the subject matter, the court shall order that the action be transferred to a court of the Commonwealth which has jurisdiction, but if that's not possible, it shall dismiss the action. So I read that to the judge, and I said, in accordance with your rules of civil procedure, I'm asking that since I've presented that you don't have subject matter jurisdiction on this because it's a political or theological issue and question of law, then that you transfer it to court. But obviously there is no court in the Commonwealth that has jurisdiction on the subject matter. So really, they need to dismiss the action. Yeah. And that's the law. And these judges are not following that law. Yeah. They're simply executing the plaintiff's will in a ministerial action. Yeah. And are liable for those decisions. Now, here's the whole thing, and tell me if I'm explaining this in a way that would make sense to you as far as, talking about what's actually happening here. It's as if to say the speed limit, because in Pennsylvania, it really disappoints me that the speed limits are so low. I mean, in Texas, we have, we can zoom sometimes in different places. But I'm coming into Pennsylvania, I'm like, 55 miles an hour. I'm like, come on, can you let me get going from point A to point B? But if I were driving, say, 120 miles an hour, and the police officer pulled me over and said, Mr. Morgan, you're speeding. The speed limit here is 55 miles an hour. And I said, I have written my own special law that applies to me. And it says that to me, I can drive 120 miles an hour. Well, let me see this law. Well, I've just declared it. I've just written it up right now. This is my law. And furthermore, because of that, you cannot arrest me. And furthermore, I have also, even if you do arrest me, I declare myself innocent. There's nothing you can do about this. It's a special, maybe that's a bad example, but I've just made a special law that applies only to me. And that's what's happening with this no-fault divorce. A person is saying, well, there's really no common law here. There's really no the things that we accept for fault. I'm going to write my own law. Yeah. I'm going to say, well, maybe I want to get divorced because I'm not happy. Maybe I want to get divorced because I've met somebody with more money. Maybe I want to get divorced because I've met somebody who's younger than my wife and prettier or does not have, whatever. I can make all of these things up. And you say, well, that's a pretty awful reason to get a divorce. But it's my law. Yeah. And not only that, you must grant it because I've written it for myself. Yeah, well, the legislators have created the unilateral no-fault divorce, and that statute actually, it allows a plaintiff to self-executing law. Yeah, to self-execute. It's a special interest, a private law under the guise of a public law. Yeah. And which, as I said before, as a public law, the application of strict scrutiny is mandatory. Yeah. And that's not being applied in these cases. They're simply granting a private interest because one individual says that that's what they want without ever offering, there's no defense at all that I as a defendant could ever bring to the court to be ruled in my favor. So it's funny that you mentioned that. I'm not a party in this at all in this case. Yeah. Yeah, you don't even have to appear. I don't have to appear. It'll never ever be ruled in my favor. There's no defense whatsoever that can be applied. So in the Texas Family Code, after they give the reasons, insupportability, the reasons for divorce and stuff like that, defenses to divorce, this is classic. And it says, I think it says condonance is not an acceptable defense or something like that. I'm like, that's it? So basically, the defense is to divorce, except for the thing that says this is not an acceptable defense, there are no defenses. It is going to be granted, period. And as you've said, no facts need to be found or anything. No. But let me ask another question. Which is interesting. So then why is the divorce master the appointed fact finder? Yeah. If there's no facts to find, because there's no right, duty, or obligation that the law prescribes. Right. Exactly.